Hi, this is Dr. Mike Chupp, and you are listening to CMDA Matters, the weekly podcast of the Christian Medical and Dental Associations. Wow, it is so good to be back home in Tennessee, and it's even better to be back here in the studio again as your host for the CMDA Matters podcast. I really appreciate Pastor Bert Jones, who did such a great job filling in for me while I was traveling during the month of June. And I want to send out a special thanks also to our podcast production team at CMDA headquarters here in Bristol, as they have kept the program going in my absence, and that includes producer Mandy Morin, as well as sound engineer Rusty Sluter. Thanks, guys. You did a fantastic job. You know, I spent most of June in East Africa with 2 weeks at Tenwek Hospital in Kenya, where my wife Pam and I served for nearly 20 years as medical missionaries. It was actually my first return to Tenwek in 6 years, accompanied by a team of 5 other physicians as well as family members and a healthcare executive, all under the auspices of our CMDA ministry, Medical Education International, helped by our MEI administrative assistant, Misty Carter. I also want to extend a thank you to Heather Travers and Ben Rhodes from World Medical Mission, who provided such excellent logistical support over the last 5 or 6 months to get all of our paperwork done, as well as medical licenses, in order to launch us for service at Tenwek Hospital last month. You know, I had the opportunity while in Africa to complete 3 interviews for our podcast, all of which were focused on an incredible new center for cardiac surgery. So be on the lookout for those interviews in the coming weeks. Now, before we get into our interview this week, I've got a very special announcement for you. Over the last couple of months, we've been sharing about our year-end matching gift campaign at CMDA. And praise God, generous friends of CMDA, including, I think, some of you listening right now, helped us go beyond the match of $320,000. In fact, by June 30th, our Vice President for Stewardship, George Courtney, tells me that we reached $365,664 beyond that match. Now, the gifts are still coming in by mail, so I will plan on giving you the total amount given for this challenge, possibly even next week for our podcast, so stay tuned. At CMDA Matters, we always want to bring you timely and inspiring interviews with guests who have been used by God to make a difference in our nation as well as in our world. My guest today is a prime example of that priority, as she is a constitutional law attorney with Alliance Defending Freedom, as well as a mom who played a key role behind the scenes in the now landmark cultural tide-turning decision of our U.S. Supreme Court on June 24th, 2022, now in the history books as the Dobbs case. Well, for several months now, as we have anticipated at CMDA, a decision being handed down on the case that people have been talking about now around the globe for the last several days, the Dobbs case from Mississippi that was argued before the court December 1st. And it was on December 1st that both Senior Vice President Jeff Barrows and I had a chance to attend a reception put on by Alliance Defending Freedom as well as the Mississippi Attorney General Lynn Fitch, and about 300 or 400 pro-life leaders who had contributed to various amicus briefs gathered on that evening and got a debrief, actually, from a panel led by 2 ADF attorneys, as well as Scott Stewart, the Solicitor General of Mississippi, and the Attorney General Lynn Fitch of Mississippi. And it was like a post-game discussion of what happened earlier in the day. And on the panel was an attorney, senior counsel Erin Morrow Hawley, who assisted the state of Mississippi in their arguments before the Supreme Court. And so at that point in time, I thought, I hope that we have a chance someday to get to talk with Erin, maybe even for CMDA Matters. And so that's happened. Now that we've had the decision for Dobbs versus Jackson Women's, Erin has agreed today to be our guest and to talk about the decision. Before joining ADF, Erin practiced appellate law with a firm in Washington, D.C., Erin litigated extensively before the U.S. Supreme Court, as well as numerous federal courts of appeals, as well as state courts. As an academic, Erin served as associate professor of law at the University of Missouri, where she taught constitutional litigation, federal income tax, tax policy, as well as agricultural law. She also taught constitutional law as a senior fellow at the Kinder Institute for Constitutional Democracy. She is a frequent commentator on legal issues, and her work has been quoted or featured in the Washington Post, U.S. News, USA Today, Fox News, the Washington Examiner, and many other publications. Critical for our conversation today is that she was a former law clerk to U.S. Supreme Court Chief Justice John G. Roberts, as well as Judge J. Harvey Wilkinson of the U.S. Court of Appeals for the Fourth Circuit Court. Erin Hawley received her bachelor's degree in animal science from Texas A&M University and her law degree from Yale Law School, where she served as a Coker Fellow in Constitutional Law and on the Yale Law Journal. She's an active member of the Missouri and District of Columbia bars and is admitted to practice before the U.S. Supreme Court, as well as various federal courts of appeals. Well, after our listeners heard that amazing bio that I just went through, Erin, thank you for joining us today on CMDA Matters at such a time as this.
Oh my goodness, it's amazing to be here and just amazing to actually be living in a post-Roe world. That's, I know, been something that so many of your members and listeners have been working for years.
Well, it's a privilege for me also to have, and no surprise to our listeners who listen to CMDA Matters on a regular basis, that our Senior Vice President Jeff Barrows is with us today. He's going to try to keep me in line. I think he's somewhat giddy in these last few days over the Dobbs decision. And I think Jeff mentioned to me the other day, I think we're all going to remember where we were when the cell phones started dinging and messages started coming in. Erin, where were you and what was your initial reaction on that wonderful day last Friday, June 24th?
Absolutely. I was actually with my kids driving back to get at my computer so I could watch to see whether the Supreme Court released Dobbs. Typically, the court does not release opinions on Friday. And so I think it was a wonderful surprise to all of us when the Dobbs decision came out that day. And it was also just very special to be with the three kids at that time.
Could you just briefly tell our listeners about your involvement in what has become the landmark case of the last 30, 40 years?
Absolutely. Well, as you know, people have marched and prayed for life for nearly 50 years. And one of ADF's, what they call generational wins, was this goal of overruling Roe, something that many people thought could never be done. So Alliance Defending Freedom has had a role in this case really from the inception. They worked with Mississippi legislators to pass Mississippi's Gestational Age Act, the law that was issued in this case. They helped defend the law below. I think they authored an amicus brief for the governor at the Fifth Circuit. And then the Supreme Court granted cert in this case, which, as you may remember, was a shock. The case sat on the Supreme Court's docket for nearly a year. In that intervening time, Justice Barrows was thankfully confirmed to the Supreme Court. Then the Supreme Court grants cert. And then a few months later, I was asked to help Mississippi with this case. Such a privilege and honor to do so. And so I worked closely with Mississippi Solicitor General Scott Stewart as he was working on the merits briefs, formulating arguments, deciding, do we really ask the Supreme Court to overrule Roe or do we go more narrow? And then helping him prepare for oral argument in the case as well. So it was just amazing to have such a front row seat in this case, really the case of a lifetime for an attorney. And then one small story I'll tell your listeners is that when I flew down to Mississippi for the first time to talk with General Stewart about this case, I actually brought my 6-month-old daughter with me. She was a baby at the time, and Alliance Defending Freedom is amazing at allowing moms to bring their children with them to work. I had a babysitter come along as well. And it was just really tangible and loud reminder of why this case matters. To have Abby with me when we were discussing the possible case or the case that might possibly lead the Supreme Court to overrule Roe versus Wade is something I will never forget.
It's so appropriate that a mom who loves being a mom and wrote a book about being a mom, I guess your title was Living Beloved Lessons from My Little Ones About the Heart of God. It would be appropriate that you would be advising Scott and the Attorney General of Mississippi. So thank you for all that work. And before I hand over to Jeff, because he's loaded today for some great to ask you some great questions about Dobbs, I'm sure Jeff has his own highlights, wonderful memories from December 1st. But honestly, my favorite memory involved you, Erin, and that is the reception that we were both able to attend that evening. And it was almost like after the Super Bowl played, being able to have Tom Brady or some other famous person on the stage. Scott Stewart was there, and you were right beside Scott and the Attorney General and Fitch. And breaking down what you heard that day and your predictions, I'm just amazed. And that was why I just wanted to get you on this program. So listeners, that's why Erin's here today, is because I was just blown away by her prescience, specifically regarding how it would be very difficult, Erin, you told us, to separate out approving the Mississippi law without overturning Roe v. Wade.
Yeah, and that actually, Mike, I'm glad you mentioned that, because that really gets into the question, one of the several questions that I wanted to get to. And you're right, I'm loaded here to hear from not just an attorney, but a senior counsel that's been very involved in this. So, Erin, knowing the makeup of the court, and I'm just curious, what was your feelings prior to December 1st when the hearing occurred? And then how did that opinion change after the oral arguments? And what, if you can remember, what were some of the questions from the justices that really thought and gave you the insight that you shared with us at that evening reception? I'd just be curious to know.
Absolutely. Well, this is really a miraculous day, as we've been talking about, to live in a post-Roe world. And the first thing I'll say is that sort of the conventional wisdom is that we have sort of an incremental court. While we have a court that has a majority of justices that have been appointed by Republican presidents, many of these justices have written about abortion and that they believe it's not part of the Constitution. But still, I remember I had a debate with a Columbia law professor, and he had actually written one of the briefs asking the Supreme Court to overrule Roe, back in the 1980s. But his thought was just that the Supreme Court would never overrule Roe. So there was just this sort of conventional understanding that Roe was here to stay, that the court might peel back on some of it and make it better. But I really commend Mississippi for going for the primary argument that everyone knows, or most everyone knows, that Roe versus Wade was wrongly decided as a constitutional matter. There's simply nothing in the Constitution's text, structure, or history that refers to a right to an abortion. And so Mississippi made this argument very powerfully in its briefs. I think some people were a little scared by that initially, but then we get the oral argument on December 1st. And that day, too, is a special day in history because the Supreme Court, for the first time in 30 years, seriously looked at the argument that Roe versus Wade was wrongly decided. And as you alluded to, the questions that we received from many of the justices signaled that they were very interested in addressing the core question of whether Roe was wrong as a matter of constitutional law. I think everyone was sort of watching three justices, the two newest justices, Justice Kavanaugh and Justice Barrett. Justice Barrett, we know, is very personally pro-life, but has not had an opportunity to weigh in on the abortion issue much. Justice Kavanaugh came up from the D.C. Circuit, had not often gotten abortion cases in that circuit. And the Chief Justice, who sort of tends to be in the middle in a lot of these cases and is more incremental in some of his approaches. So at oral argument, Justice Kavanaugh said at least 3 times that the Constitution is silent on abortion. So shouldn't the Supreme Court be, quote, scrupulously neutral? So it seemed at that time that he was really trying out this line. And in fact, if you look at his concurrence that was issued last Friday in Dobbs, he pulls that line through and says, yes, the Constitution is silent. That means this court has to be neutral and cannot pick sides. Similarly, Justice Barrett, along with Justice Kavanaugh, pointed out that some of the court's best decisions have been ones that overruled prior decisions. A lot of the opposition was the idea that, Roe and Casey have been decided. We shouldn't disturb that. We shouldn't upset or overturn a precedent. And Justice Kavanaugh said, no, that's wrong. Brown versus Ford, for example, famously overruled Plessy versus Ferguson, which had the horrible result of allowing racial segregation in education. So he said, no, the court can and does overrule cases. Some of its best cases have been those cases like Brown. And then Justice Barrett also pointed out that things have changed since 1973. She mentioned the availability of adoption in all of the 50 states and the District of Columbia, signaling that she thought the reliance interests were not sufficient to overcome the egregiousness of the Roe decision. Even the Chief Justice had some great questions. He pressed the other side on the fact that the United States is one of only a handful of countries, 6 to be precise, that allow abortions up until the moment before birth. And those countries, of course, include North Korea and China. And that's not really sort of the human rights company that we should be keeping, the Chief Justice suggested. So I think after oral argument, the pro-life community and certainly Mississippi and ADF were extremely happy and encouraged that Roe might actually be on the chopping block.
Well, I'm sure many of our listeners would like to get your take, since you served in the court, a clerk for the Chief Justice, John Roberts. This leaked to Politico on May 2nd. Tell me what your response was when you heard that it happened. What's it done to relationships inside the court from your past experience, and what's happening now to investigate it and for the Chief Justice to chase this down?
So the first thing I would say is just that the leak was an egregious breach of protocol and of the trust that is placed in everyone that works at the Supreme Court. There were a couple of articles that came out after the leak and tried to normalize this and say, this has happened before. The fact of the matter is that's simply untrue. A draft opinion has never been released prior to it being ready to go out into the world and be released by the court. So it was an egregious breach of trust, breach of legal ethics. And it resulted, as we saw, in the protests and threats of violence against various justices who had voted to strike down Roe. That sort of thing is just, it's illegal under federal law and shouldn't have happened. So I very much hope that this never happens again, that the Supreme Court is able to appropriately punish whomever leaked this decision. And as a clerk, when you go in to work at the Supreme Court, one of the first things you do is you sign a confidentiality agreement. But it's much more than a signature. There is this understanding that you are working for one of the institutions of government in a very special capacity in which you will be able to work with justices on opinions that really matter, like Dobbs. And that trust allows young law clerks the ability to get this tremendous experience. And so it is tremendously damaging, I think, to the court as an institution and also to the relationship among employees and clerks at the court. So a really bad situation. But I love Chief Justice's the Chief Justice Roberts' statement then, where he said that this would not impact the deliberations at the Supreme Court. And we saw that come to fruition with the Supreme Court's opinion overruling Roe in Dobbs.
Are you surprised that he didn't join the other 5 in concurring with their opinion to overturn Roe v. Wade?
I think one of the great things to recognize about this opinion is it is 6-3. The media has been quick to characterize this as being an extremely fractured decision, but we actually have 6 votes, including the Chief Justice, to uphold Mississippi's really kind of modest and common sense law. As many of your listeners know, Mississippi's law applies at 15 weeks. And as you know much more ably and capably than I do, a baby is really well developed at 15 weeks. She can open and close her hands. All her organs are fully developed and functioning. She can hiccup. she can quite likely feel pain. And in the face of all of this scientific evidence, Mississippi determined that they wanted to protect life. And the Chief Justice agreed that Mississippi's law should be upheld, even though Roe and Casey said that the states could not protect life, no matter how well developed a baby was or how compelling the state's interest in protecting life, until viability, which is around 21 or 22 weeks. So that in and of itself is a huge win. There are 6 votes to uphold Mississippi's law. I certainly wish the Chief Justice would have gone all the way and went ahead and joined the opinion overruling Roe. But you'll notice in his opinion, he nowhere says that Roe or Casey were rightly decided. Instead, he simply says, I don't think we need to decide that question to decide this case and uphold Mississippi's law.
Well, Erin, that maybe gets to my question, and you've used this term a couple of times already in the interview, and that is the term of incrementalism. Mm-hmm. And so if you could explain for us as a bunch of healthcare professionals and non-legal people, what does that mean? And I know that Justice Roberts has been called an incrementalist. And is that true? And how does that fit into this decision?
Absolutely. So incrementalism is sort of an idea that encompasses judicial humility and then also only deciding the case in front of you. So I think Chief Justice Roberts would view his decision as an incremental one, grounded in the idea that a Supreme Court case should only go as far as necessary. Now, there are some sort of caveats and pushback to that. As Justice Alito would no doubt say, the Roe versus Wade decision decided in 1973 has imposed egregious harms on this nation. It has disrupted the political process. It took the issue out of the hands of democratic debate. It has profoundly damaged the court as an institution, and it has, harmed 60 million innocent children who have lost their life under this decision. So, and there have been other cases in which all of the justices have voted to overrule decisions. So incrementalism, I think, is this idea that the court only decides what's necessary. I think Alito and the majority thought that overruling Roe was what was necessary in this case. And along with that, I think I should also say that it's difficult to find a middle ground. As we discussed on December 1st, it's really tough. Casey called the viability rule the central holding of Roe. And that meant states could not protect life until 22 or so weeks, 28 weeks at the time of Roe. So it was a moving target. But Casey called it the central holding of Roe. And yet the Chief's opinion upholding a middle ground says, well, we're going to move the viability rule. We're going to get rid of it. Actually, he says we're going to discard the viability rule, and we're just going to impose this idea of a reasonable opportunity for a woman to have an abortion. But it's really hard to get there under the case law. So I think a fair reading of the Chief Justice's opinion is, in fact, an overruling of Roe, at least in large part. And so that's why I think the majority went all the way.
Well, I'm sure you, like all of us, are aware of all of the news that's been out since the opinion was released last Friday. And of course, those on the conservative side have said that Justice Alito did a terrific, masterful job of writing the opinion. And I know I'm biased, but I've read through all of it, and I thought, I can understand this. I'm not a lawyer. I can understand. It makes a lot of sense to me. The other side, of course, the conservatives have also described that the dissenters' arguments are poorly written and legally unsound. And I guess my question to you, as a constitutional attorney, are those views the result of conservative bias, or do you think there's legal basis for that opinion?
So I agree with you completely. The Justice Alito's opinion is masterful, is thorough, it's eloquent, and it really goes through each and every basis that has been alleged to support a right to an abortion, and just shows that those bases are absolutely without basis. So he makes clear that there's nothing in the Constitution's text that supports a right to an abortion. He talks a lot about the liberty interest that is encompassed in the 14th Amendment. And under the liberty interest, the Supreme Court has said that it does encompass some things that aren't specifically mentioned in the Constitution. But this is really dangerous, right? As the Chief Justice has said in other contexts, when the court is sort of extrapolating from the text, we need to be really careful about what it is the court is saying. And so that means that when the court has looked at liberty interests, they have required for a right to be found that it be, quote, deeply rooted in our nation's traditions and history. And that is a way of tying a constitutional right to a historical basis rather than sort of judicial bias or preference, however well-meaning judges may be. So the court has always required, or most, I should say, the court's current test for a liberty interest is this deeply rooted right. And as Justice Alito's opinion just masterfully lays out, there's absolutely no basis for a historical right to an abortion in this country. It was illegal under the common law. It's always been unlawful. He goes back to Blackstone and talks about how Blackstone sort of decried abortion as a crime. He also talks about the time of the 14th Amendment, which was passed in 1868. At that point in time, 3/4 of the state made abortion a crime at all points of pregnancy. And most of the states did thereafter. So from this time period, we clearly see that there's absolutely no historical right to an abortion. And I think that really is the heart of this case. And as for the dissenting opinion doesn't dispute this history, which is really quite remarkable. Because one thing that as you know, as medical practitioners, is that Roe actually got the history wrong. So the majority, Justice Alito, corrects the sort of history that had been misappropriated in Roe. And the dissent in Dobbs, in our new opinion, does not dispute this history. They admit that 3/4 of the states criminalized abortion in 1868 and that there's no right to abortion to be found. But what they say is we can't look to a specific point in time. We have to look to the arc and sweep of history. But with respect, that's not really much of a test at all. As Justice Alito points out, there's no limiting principle. And unfortunately, a test like that just leaves a lot of room to judicial discretion. And again, judges, however well-meaning, when they have a test like that, might implement some of their own personal policy preferences. And that's why, as the chief and Alito said, we need to stick to history. So again, tremendous opinion by Justice Alito. And I think the dissent's argument really just is unbounded.
Erin, I went to school as I crammed for this interview yesterday, reading through both the majority and the dissenting opinion. And I've heard over the years originalist, textualist versus someone who believes in a living constitution. And I mean, it seems to me, I haven't read too many Supreme Court opinions or decisions, but it seemed to me this is a classic setup of originalist versus living constitution. I mean, Stephen Breyer and the other two clearly didn't spend much time, as you said, talking about history, but just talking about what does the Constitution mean for today? And that's what we should be focused on. And in fact, really slammed the 1860s and how men viewed women, and that should come into play in today's modern day interpretation of the Constitution.
Absolutely. But, one of the things I really liked about the majority opinion is that it pointed out that in Mississippi, 55% of voters today are women. And the majority's opinion give those women a chance to express their views on abortion rather than leave it in the hands of, in Roe, 7 men. And those 7 men in Roe, as you may be aware, had sort of a dim view of motherhood. They said that motherhood forced upon women a, quote, bleak and distressful future. And that's just not, I think, the reality of motherhood, as almost all moms would agree. And in addition, we have the wide availability of contraceptive methods that have both a median cost and a median failure rate approaching 0, along with thousands of families who are waiting with eager arms to adopt children. So I think the dissent's view of motherhood, at one point they call it sort of a nightmare. Again, I think that's simply untrue and a demeaning view of motherhood. And the reality is that it is the majority's opinion that is democracy reinforcing for 2 reasons. One, when the Constitution does not provide a right to an abortion, it leaves that issue to the states. And second, in Mississippi, as we see 55% of the voters are women who will now have a say. In fact, the 15-week law passed Mississippi overwhelmingly with a high percentage of women voters. So I think the Supreme Court is out of touch with, or I should say the Supreme Court's dissent in Dobbs is out of touch with the reality of motherhood.
Well, Erin, I have a question that really gets back to probably your days as a clerk for Justice Roberts. And it's just, it was interesting to me to read through this whole opinion with the dissenters and the majority opinion and the level of disagreement and how I don't want to say they attack the arguments of each other. And so I found myself wondering whether these disagreements spill over into personal relationships. I'm sure many of our members are aware of the close personal relationship between Justice Scalia and Justice Ginsburg, who I can safely say did not agree on probably on most cases. So what is the work environment within the court itself? Are they able to maintain good working relationships just after these things are released and they've had these disagreements with each other? What's that like?
I think they are. I think this case and Dobbs probably stretched those relationships a bit, just given the, sort of heated, passionate responses people have to the issue of abortion. But recently, actually, Justice Sotomayor praised Justice Thomas. And she did this in the context of noting that Justice Thomas knows the name of everyone in the building, which I can attest to. He knows about their families. He knows if their sons or daughters are in college, regardless of whether they're the elevator operator or a colleague justice. And so Justice Sotomayor pointed that out and sort of the good man that Justice Clarence Thomas is. And so I think there still is that collegiality that they respect one another, even though they disagree so strongly in some of these cases. So my hope is that continues and evidence is that it is.
That's good. I'm glad to hear that.
Well, Erin, at that banquet December 1st, the reception to kind of celebrate what we saw and heard in the oral arguments, I will never forget what I believe the title is Executive Director Michael Ferris for ADF shared. And I have shared his words to us that evening in so many different venues and so many different friends and CMDA members, that Michael Ferris took us back to the Old Testament and said that if and when Roe v. Wade is overturned in June, that we will have suffered through, and 70 million plus deaths, it will have been 49 years under Roe v. Wade, and that now those who are the children of God, just like in the Old Testament, the children of Israel, will celebrate a year of Jubilee. Now, against that is the fact that there's so much rancor and anger and maybe even intimated violence and so forth. But so how can we move forward with a spirit of celebration and yet understanding that maybe half of America is really angry right now?
So I love the point about Jubilee, because for 49 years, there has been this sort of spirit of slavery and of death and destruction that has now been released with the Supreme Court's decision in Dobbs. And I think you hit a key point that not everyone is happy with the Supreme Court and the Dobbs decision, and many are really upset. And I think our response as Christians is the same response that the early church had, and that is to love our neighbors, even if they disagree with us, to love even pro-abortion advocates. As ADF has long said, abortion takes the life of the unborn, but it also harms the life of the mother. And so we need, as church, as physicians, as communities, to come alongside these women and support them, and so that they may flourish. Texas has great programs that provide education. They provide classes for mothers and fathers. They provide housing, just really practical benefits to helping these moms and their babies flourish and thrive. And so I think we just need to show our true commitment to life, unborn and throughout life. And I think it's really an opportunity for the church and pro-life organizations like your own to be the hands and feet of Jesus, and just to show that we respect and value life. And the decision is a huge, huge legal victory. But as you mentioned, it's really just the beginning. It's a rallying cry to protect life. And with the shackles of Roe gone, we can finally do that, which is tremendously exciting. It's also a bit daunting. It is a huge effort and project. But as we've seen with this decision, nothing's impossible with our God.
Erin, thank you so much for setting aside this half an hour to talk with us and to answer some questions and to do that with such grace and insight. And I know that you've got a lot of these interviews right now, and so we want to let you go. But may the Lord bless you and make His face shine upon you, and may you be winsome, full of conviction, and that compassion that you just mentioned. As you and ADF, we're so grateful for Alliance Defending Freedom. They've helped CMDA in so many ways over the years, and you are a wonderful partner with us as we protect and promote sanctity of life.
Thank you so much for having me and for all of your amazing work.
I hope that our conversation with ADF Senior Counsel, Mrs. Erin Hawley, helped give you a little inside perspective on the historic Dobbs decision. I want to encourage you to download and read the actual Dobbs decision document, as Jeff Barrows and I have both done. It's a PDF of that decision from our Supreme Court, which we have made available with a link in our show notes today. You know, if you and I were to travel together back in a time machine to a different month of June in the year 1944, and we could have a personal audience with General Dwight D. Eisenhower, Supreme Commander of the Allied Forces, just a couple of weeks after Allied troops stormed the beaches of Normandy, I wonder if his perspective, his emotions, might be similar to those of pro-life leaders in America right now. No doubt he would be elated and celebrating with other Allied leaders under his command at the success of taking that critical beachhead in France against a determined enemy, the entrenched German army. And yet, General Eisenhower would likely tell us about the incredible obstacles that remained, so many more battles to fight, many unknowns for Eisenhower and the Allies. So many more sacrifices would be required by American and British and French forces in order to defeat Hitler and end World War II. You heard me recount with Erin Hawley the words of her boss at ADF, Michael Ferris, that we have now entered a year of jubilee with the downfall of Roe and Casey. And yet, friends, this is only a beachhead, if you will, in the war against the evil of abortion on demand in our country today. There will be significant battles in every single state of our union, with the forces of our enemy concentrated in great numbers in many of our states. One of our critical strategies at CMDA is to equip loving messengers of truth in healthcare. The Apostle Paul told the Romans in chapter 12 of his letter to them in verses 9 and 10, "Love must be sincere. Hate what is evil. Cling to that which is good. Be devoted to one another in brotherly love." Please join us as a loving messenger of truth to protect the dignity of women as well as their babies in the weeks and months ahead. If you'd like more information on how to get involved in your particular state, please write us using the email address communications@cmda.org. Our Director of State Public Policy, Ms. Nicole Hayes, would be thrilled to talk with you and explain how you can engage and become a champion for life during such critical days, promoting the sanctity of human life. We also have available a position statement on abortion. It's a highly researched and referenced document that covers the biblical, biological, social, medical, and ethical arguments against abortion, as well as recommendations for the Christian community and Christian healthcare professionals. You can just go to our main webpage, cmda.org, and you'll find this position statement and many others like it under the heading Policy and Issues. You know, I've got a couple of events that I want to tell you about that are happening in the next few months at CMDA. First is our upcoming conference in Dallas, Texas. One of the topics that we continue to get requests about is the topic of sexual identity. So this conference is to help meet that need within healthcare. We are partnering once again with the Hendricks Center at Dallas Theological Seminary to host an in-person conference we are calling Critical Conversations on Identity and Gender. As Christians in healthcare, how do we speak effectively, truthfully, and graciously while giving care in such an environment? Please join us for this critical conversation as we consider the theological, medical, legal, and pastoral perspectives on identity and gender. You can join us live or virtually in Dallas, Texas on August 5th and 6th. Registration is now available by going to cmda.org/events. The second event is specifically for women of CMDA. You're invited to join women physicians and dentists in Christ, known around here as WPDC, at their 2022 annual conference, September 15th through the 18th in Newport Beach, California. Their theme this year is found in Matthew chapter 11, verse 28, which says, "Come to me, all you who are weary and burdened, and I will give you rest." Topics will include burnout, boundaries, well-being, dealing with difficult patients, end-of-life care, and much more. There are student scholarships available for currently enrolled medical and dental students, and there will be a men's track available for those husbands who'd like to join in. So please join the ladies of WPDC for a weekend of fun, fellowship, and worship as you find rest in our Savior. If you'd like more information and to register, just visit cmda.org/WPDC. As I bring us to the finish line, I want to encourage you to tell your friends and family about CMDA Matters. And if you're a healthcare professional, tell your colleagues and staff about us as well. Next week, Dr. Bill Griffin and I will be hosting Dr. Kathy Scarborough, one of our faculty for the Faith Prescriptions on-demand video training series. Kathy is very passionate about sharing her faith and the gospel with her patients. I am predicting that her testimony, as well as her example, will be just as much a challenge to you as it was to me. Challenging Christians in healthcare to bring the hope and healing of Christ to the world, well, that's what we wake up every day here at CMDA thinking about. It is the vision that energizes this ministry of changing hearts in healthcare. It's a vision that matters most to CMDA and CMDA Matters. Thanks for listening today, and we'll see you next week, Lord willing.
This podcast has been a production of the Christian Medical and Dental Associations. The opinions expressed by guests on this podcast are not necessarily endorsed by the Christian Medical and Dental Associations. CMDA is a nonpartisan organization that does not endorse political parties or candidates for public office. The views expressed on this podcast reflect judgments regarding principles and values held by CMDA and its members and are not intended to imply endorsement of any political party or candidate.